Good morning. Thanks for coming. I'm Dave McHenry. This next section is a section that I've titled Escaping Kvaerner. And we've got a pretty sophisticated audience here. So when you see the term Kvaerner and you see it highlighted, many of you may be thinking, this guy's going to talk about insurance coverage. And so we're going to talk a little bit about insurance coverage. We're going to take a look at what the lay of the land looked like before the Kvaerner decision. Then we're going to see how Kvaerner changed that. And then we'll see what the trends were following the Kvaerner decision. And then ultimately we get to December of this year, and it's in December of this year when we begin to see a trend reverse a little bit. And I can tell you that it's a favorable trend for the general contracting community. So it was in October of 2006 when the Pennsylvania Supreme Court issued a decision that I think surprised both the general construction industry as well as the insurance industry. And that case was a case known as Kvaerner Metals versus Commercial Union. And before we talk about it, I just want to revisit, insurance coverage in the context of faulty work before Kvaerner. So in other words, prior to the Kvaerner decision, what coverage was available in connection with faulty work? I think there was a consensus among not only the insurance industry, the general contracting industry, but also the courts. I think there was a general consensus that if I am a general contractor and I've got general liability coverage, I've got coverage for three types of occurrences. Third-party property injury, that is, the work injures someone, right? Third-party property damage, the work damages property other than the work itself. And then finally, damage to the work of the project itself, as long as that work was caused by faulty work attributable to a subcontractor. So before Kvaerner, that was pretty much universal. I think everyone knew it. I mean, that's why general contractors were paying their premiums. That's what the insurance was being written for, and it was pretty universal. Well, we then get to the Kvaerner decision. And these are the skeleton facts of Kvaerner. And to add a little bit of meat to the bones, it was in the mid-1990s when Bethlehem Steel entered a contract with Kvaerner to design and manufacture a coke oven battery. Now, the allegations against Kvaerner were that there was some premature grouting of bricks. And as a result of that, the coke battery, it never functioned as intended. Okay? So there were no allegations of third-party property damage. There were no allegations of third-party personal injury. The allegation was this coke battery never functioned properly. Kvaerner got sued by Bethlehem Steel. Kvaerner turned the matter over to its insurance carrier and said, Mr. Insurance Carrier, I've been stroking checks for my premium. I just got this lawsuit. The allegation is that one of my subcontractors, right, who was responsible for grouting, has caused damage to this coke battery. And as a result, I have coverage for that. Well, the insurance carrier disagreed, and ultimately the court disagreed. And I'm going to put the holding up here in a second. But what the Supreme Court ultimately said in Kvaerner was that faulty work, right, regardless of who performs it, faulty work is not an accident. Therefore, a subcontractor's faulty work is not an occurrence under a CGL policy. And so what Kvaerner really did was it eliminated what is referred to as the subcontractor give-back coverage under the CGL policy. And so this is the language of the court's holding in Kvaerner, and I'll just read it to you and then we'll break it down on the next slide. The court said, we hold that the definition of accident required to establish an occurrence under the policies cannot be satisfied by claims of faulty workmanship. because those do not present the degree of fortuity contemplated by the ordinary definition of accident. That's what the Supreme Court wrote in the holding in Kvaerner. And so we break it down. And really, when you break down Kvaerner, you see that, to trigger an occurrence, you need an accident, right? And what the court said was, faulty workmanship, that's not an accident. You can't accidentally do poor work, okay? That's what the Supreme Court was saying in Kvaerner. It said that type of claim, that claim for faulty workmanship, it doesn't present the contemplated degree of fortuity. And you saw even a reluctance on behalf of the Supreme Court to convert an insurance policy into a performance bond. And so the takeaway from Kvaerner was a very narrow view of what coverage was available under a general liability policy. Insurance carriers took Kvaerner and they turned it into a bright line rule. And what insurance carriers were arguing in cases that post-dated Kvaerner was that if there's an allegation of faulty work, that's not an occurrence. So if you've got a complaint against you and the sum and substance of that complaint is faulty work, there is no insurance coverage. That's what you saw carriers doing in the aftermath. And this presented, as you could imagine, a significant problem for general contractors, because general contractors were standing there scratching their heads saying, wait a minute, I no longer have coverage for damages arising out of faulty work performed by one of my subcontractors. So at the end of the day, I'm holding the bag, even though I paid insurance premiums, and even though traditionally I had coverage for this type of occurrence. And you saw carriers advancing that type of argument in a few cases. There was a case in 2007, Miller's Capital. There was a case in 2009, Erie Insurance. And those were cases where insurance carriers were saying, hey, look at Kvaerner, look what it says. There's this bright line rule. What you're identifying here are allegations of faulty workmanship, and there's no coverage. The carrier also made that argument in the Indelex case. And that's where we see the judiciary starting to reverse the trend a little bit. This was a case that was handed down on December 3rd, 2013. And for those of you in the room who are in the contracting camp rather than the insurance camp, this was probably a breath of fresh air. The facts of this case were Indelex was a manufacturer of windows and doors. Indelex found itself involved in a bunch of cases resulting in not only personal injury, but also third-party property damage. There were allegations of water penetrating the building envelope and causing mold, cracks, things of that nature. So those were the types of allegations that you saw against Indelex in these underlying cases. As I indicated, the insurance carrier in this case said, this is really clear cut, right? As a matter of law, there is no coverage. They moved for summary judgment. They said it's undisputed. What we're talking about here is faulty workmanship, and there's no coverage for faulty workmanship. And they cited Kvaerner, and they cited Miller's Capital, they cited Erie Insurance, and the trial court agreed. And then Indelex appealed that decision to the Superior Court. The Superior Court reversed and remanded. And the Superior Court went through this, relatively thorough and, admittedly convoluted analysis of Kvaerner, Miller's, Erie Insurance, and they ultimately reversed and remanded. And I think there's 2 points from the decision that are probably worth highlighting. The first point relates to this quote. and I'll just read this quote for you. Because the underlying complaints alleged defective products resulting in property loss to property other than Indolex's products and personal injury, we conclude that there was an occurrence. So the first thing that the Indolex court did was, if we revisit what I was saying about 8 minutes ago, before Kvaerner there were three instances for which coverage was available. One was third-party property damage, one was third-party bodily injury. And this is the Indolex case saying, hey, Kvaerner never changed that, right? So this is an indication to the community that if you're dealing with third-party property damage and you're dealing with third-party personal injury, and it's stemming from faulty work, you actually have coverage for that. Kvaerner never changed that. The other thing that the court did was they took a look at the definition of occurrence. And one of the just general rules of construction in these insurance coverage cases is that the courts are going to look at the policies. And if there is any ambiguity in the policies, the court is going to give weight to the insured, the person that pays the premium, the general contractor. And so what the court did was it compared the definition of occurrence in the Kvaerner policy with the definition of occurrence in the Indolex policy, and they said, really, we're talking about apples and oranges here when you look at this policy language. They said that the language in Kvaerner is relatively objective. And so when we look at that, there really is no ambiguity. So that rule of construction that, hey, we're going to give favor to the insured, that's out the window. But when you looked at it in Indolex, there was a degree of, subjectivity that was thrown in there. And so the court said, we've got somewhat of a distinction here, and we've got to construe this in favor of the insured Indolex. And so the court ultimately reversed and remanded. Last time I checked, and it was not as recent as the last time Matt checked, but last time I checked, the carrier had requested re-argument and or reconsideration. And that request had not been adjudicated by the Superior Court. So we will have to stay tuned to the Babst Calland Construction Law blog to see whether or not the Superior Court is going to take a second look at this. And we will also have to stay tuned to see, what the next case says, because there will be another insurance coverage case that's going to look at Kvaerner, it's going to look at Miller's, it's going to look at Erie, it's going to look at Indolex, and we're going to figure out, perhaps, what does all this mean? The other final practical consideration is that in light of sort of this uncertainty about, hey, I'm a general contractor, do I have insurance coverage for faulty work that's performed by one of my subs on the job? You can talk with your insurance brokers, and there are endorsements that you can apply for that will eliminate, that risk and make sure that you have that type of coverage.